come in, probably law enforcement would come in and investigate the case, refer it on to the district attorney's office, and from there a decision would be made in terms of prosecuting or not. There may be things like money laundering, there might be questions of fraud, misrepresentation, there might be misconduct in public office.
The point is,
good morning. Welcome back to Talking Racine. On the far left is Mr. Jim Spodek, the producer of this show. Mr. George Myers to my left. I'm Dr. Ken Jorgen, your host. And we have a special guest with us today, and it's Mr. Walter Stern. Walter Stern is one of the attorneys from the firm that is representing Sam Azarian in the lawsuit against the city that we kind of went over for you last week. Now, that lawsuit is directly a result out of the Machinery Row project, which never really went anywhere and cost many millions of dollars. We're figuring at least 10, and it could go as high as 20 if things go wrong. So we're going to talk about that a little bit. In fact, it's probably going to be the whole show, right? So, Walter, how did you get involved in this? You want to give us a little bit of your background?
Sure. I've been a lawyer since 1974, and I seem to attract these type of cases. I do civil rights cases, I do employment cases, and I've done a lot of cases involving appeals to the Court of Appeals and the Wisconsin Supreme Court. And these kind of cases just seem to have followed me around like a kind of a wistful dog, and that's why I'm here.
Well, in my opinion, this is some of the most important legal work being done in the entire country. I mean, not necessarily this case, but the kind of work that you're talking about.
well, I'm sure glad you got in on it too, because we're tired of seeing people screwed. Shall I use that word? And,
You can use that
around,
word,
around this particular issue.
Sure.
It's just been disastrous, and I'm glad when I read this suit, I was so glad to see something like this.
Now, you want to run us through a little bit of
Sure.
how you became acquainted with Sam Azarian and
Sure.
how this unfolded?
Out of the blue, I get a phone call from Patrick Fagan.
Yeah.
I guess he had heard from me, about me, somewhere. I think I was on television or doing some case, and he said, "Will you talk to me?" And I said, "Well, I'm going to be retiring. Matter of fact, I'm actively retiring." And then when I talked with Pat, Sam Azarian came along, and we started talking, and I thought, this is a wreck. This is a train wreck. It's already occurred, and it got my interest to sort of pick up some pieces and see if I could make a whole car out of it, or would it continue to be a wreck.
Right.
So that's how I got involved.
Now, as you've gone through this case, I mean, does this strike you as being a little unordinary? This is kind of an unusual case from what I see of it, but I'm not an attorney. Have you experienced much like this in your
No,
work?
I've had some eminent domain cases involving like businesses or widening of the streets, and they're really pretty straightforward. I mean, you have a right to fair market value of your property. If you have a business, you get moved somewhere equivalent. If you need to pay rent and you're a tenant, you get a rent differential and you can continue to rent.
Right.
And if you're a business, you get relocated. And if you own the business, you get relocated. And if they buy real estate, you get the value of the real estate.
It's very standard.
It's really
That sounds
standard,
like it. Right.
and it's not all that tricky. Most paralegals can do it.
And in fact,
frankly.
there are state statutes that regulate all of this, right?
Yeah, there is Section 32 of the Wisconsin Statutes, and then there's 92 of the Administrative Code that attempts to regulate these kind of eminent domain cases. And it should be straightforward. And in looking at this case, it could have been straightforward.
Yeah.
You file a plan with the Department of Administration, get it approved for relocating businesses. and buying them. Gets approved, then you go to the individual business people involved. You figure out the value of the property and whether or not it can be moved and where, and you move the person to another business, and if they have to move and they're a tenant, you give them moving expenses, and you make sure that they get able to rent and make sure it's equivalent, or they use the term comparable, and it really should be easy. It's not all that difficult, especially since, and this makes it difficult, since the United States Supreme Court came down with Kelo versus City of New London. It used to be that eminent domain meant that the government had to use it for roads, bridges,
Public works.
Yeah. Or perhaps like a sewage district or something like this. It had to be for public purpose.
Right.
The Supreme Court said no, it's okay if it's for a public use. That opened Pandora's box for business and government to enter what I can refer to as an unholy alliance.
So,
Very
so
difficult.
As it stands now, as a result of that Supreme Court decision, they could actually take somebody's land and put up an amusement park. I mean, that's a bit of a stretch.
Yeah, as long as it was for a public purpose.
And that
they could
purpose
prove
is
that
generally around
purpose.
taxes, isn't it? Isn't that what it is?
Well,
To
yeah,
increase the local revenue to the local government. That's about the extent of it.
Well, the Kelo case involved like an urban renewal project.
Yeah.
And all you would have to do is say, this is for redevelopment, in this case, or this is going to be like a village or city or town park
Okay.
or amusement park. And then, of course, they'd look at, is it going to be a profit or non-profit? All of that's important.
It takes a little broader than taxes. It's also going to improve the look of the
Right.
community, something that type
Right,
of
and
thing.
courts are not going to interfere with the public purpose idea, rather than public use.
And to hell with the private interest.
Right.
You're just one person, you don't count.
Yeah, and like, because in Kelo they declared it a district that was blighted, quote. They could go on and do
Very close to Doc's
urban
Arc here,
renewal.
blighted stuff.
You could do urban renewal. But lately we've seen that you can just call it blighted. I mean,
exactly right.
if it's a wonderful mansion, you could say it's blighted because it's inconsistent with the business we want to.
That's why we're joking
go
about Doc
there.
here.
Yeah.
That's his neighborhood when
Really?
I'm in a
and
TIF
it was
district.
blighted.
Yeah, what I'm saying is, blighted means whatever you want.
It means we want the property.
Right.
But, all right, so I got a question. So it went to the City of Racine now came in. And now because of the lawsuit, they came in and, and I think we're all in agreement, they put up a straw man, basically to come in and purchase this property to do what? Is it to avoid a relocation?
Yes, they came in and they wanted to avoid relocation. So they got Rodney Blackwell involved under the business name of FDP, and they got him involved. Essentially, he was an agent for the city, but they wanted to keep it a private sale so there wouldn't be relocation. And there's even letters from the city attorney indicating this is a private sale, this is not eminent domain. We don't think that because of that anyone is entitled to relocation.
Now, Walter, in watching national events, I'm seeing there's a difference between corruption and actual illegality. Would you say this was in the band of corruption, or is this just flat out illegal?
It's such a mess. I honestly, I think at this point it's corrupt, but I would have to really look at it carefully. They tried a federal case in this involving the Machinery Row, It didn't work. They had RICO, which is a Racketeering and Corrupt Practices
Right.
Act.
Right.
It deals with crimes, 2 or more crimes, part of a common purpose, commonly referred to as racketeering, essentially.
Right.
I'm not sure it reaches that level, but the real big problem is the people who are around who might be responsible are immune from liability.
Because they work for the city?
No, there's under 893-80, parent 4 of the Wisconsin statutes, any city official acting as a legislative or quasi-legislative purpose, which should take into consideration administrative agencies, or judicial or quasi-judicial, are immune.
What if it can be proven that they actually knowingly committed crimes?
Well, then you go to the criminal code.
Okay.
Then you're no longer in the civil venue. You're in the criminal venue,
Right.
which means that you have a prosecutor that has to make a decision, investigate the case, perhaps have law enforcement come in. Probably law enforcement would come in and investigate the case, refer it on to the district attorney's office, and from there a decision would be made in terms of prosecuting or not. There may be things like money laundering, there might be questions of fraud, misrepresentation, there might be misconduct in public office.
The point is, you'd have to pinpoint that crime.
Right.
Now, with regards to this case, do you see anything, as you look at it, that would constitute a crime?
What I see in this case, I see fraud, but whether it rises to the level of criminal fraud, I'm not quite sure. I'm still.
Could you
it's a
explain
working-
how that,
yeah,
how that
yeah.
what the difference is?
The city basically said, we're although this is going to be a public purpose, we're going to act like it's a private purpose. And then we're going to go get
That's a little bit of fraud.
Rodney, yes. Then we're going to get Rodney Blackwell involved, his business,
It's a little more fraud.
to make it more of a private business, even though conceptually, when it started out as a Root River project,
Right.
a long project, even though it clearly is eminent domain. So there could be misrepresentation. Perhaps Rodney Blackwell could be involved in that misrepresentation. City officials could be involved in that misrepresentation. That's the main misrepresentation.
Oh, I think they're in it up to their eyeballs.
Yeah.
I mean, they're the ones that perpetrated it. They're the ones that
No,
sustained
why?
it. they're
Here's
the one
I
that
got a
concealed
question.
it.
One of them was they hired an outside firm. The city attorney, instead of handling the like you said, a paralegal could put this together. Instead of the city attorney handling it or a city law firm, they hired an outside firm to come in
Yeah.
and do the paperwork, and almost like we want hands off. I think knowing quite well that this was fraudulent was, they were borrowing the money from the city, and he was not the actual real purchaser. The purchaser was, and if you go through your complaint, it even said that Olson's attorney, it says in your complaint, when I met with the city, we agreed that the total price would be reduced from 4.5 to 3.5, which is the client's bottom line. That was they were dealing directly with the city. So Blackwell actually was second in that. So, there's definite, in this complaint, it points to the fact that the city was the real purchaser. But they were telling the representatives of the city, the aldermen and whoever else there, that it was a private purchase. Now, to me, if you're taking tax dollars and utilizing it to purchase property fraudulently or misrepresenting it, I don't know, George.
Well, the first thing is the city's obviously involved, so you're going to
Sure.
There's going to be the relocation costs, even though it's a private. This is my understanding of the law. Now, you correct me if I'm wrong on that. Even though it could be considered private transaction between the company and the buyers. Because the city's involved with it in an overall plan, it still now becomes subject to relocation costs. It's considered.
Well, that's the interesting.
Is that correct?
That's an interesting question, because what they tried to do is avoid the relocation costs. And they even put on the offer to purchase these three businesses out of the 4.5 million. They even said on offer to purchase and the closing statement that the city's view is that it's a private sale, and they would be more or less giving up the right, to claim relocation costs.
Didn't they actually put that into the contract? That
Yes.
they specifically asked the sellers to forego their rights to relocation?
But
Which my understanding is, according to state statutes, even if they wanted to, they couldn't forego their relocation costs. They couldn't sign their rights away.
And that's the fraud.
Yeah.
The fraud is that they bamboozled three sellers, basically, of their property into believing that they didn't have a right under the eminent domain for moving costs, relocation costs, and that type of thing.
Well, my understanding was, because that's on the transaction. All right, so it kind of looks private from there. But when you get back to what the buyer's going to do with it, he's going to use taxpayers' money. He's going to use the taxpayers' program to develop it in a certain manner. That's what makes it also a government thing, and so then brings in the relocation cost.
Right.
Is that a correct analysis?
That's what they should have done. They should have handled it
Yeah.
as a eminent domain. That's what it is.
Yeah.
I mean, an elephant's an elephant. Like, I know that the story of the 10 men from Hindustan, they looked at an elephant and they thought it looked like a snake and a stick.
I think they were blind, right? They were blind, so they were like feeling it.
No, the 10 blind men from Hindustan. In any event. So they basically tried to cloak this as a private sale and throw in Mr. Blackwell on top of it, who's a private business.
Right.
And then they used taxpayer money to fund this.
Right. And then, well, now going back into it, in your complaint, you also have Blackwell had no guarantees. He had no personal guarantees. He really had no skin in the game.
Yeah, no
say.
$30,000 at first.
Yeah, but he got that.
He
back.
got that back. Yeah.
And then, of course, there was you called it a holdback
Yeah.
of 10% from all the sellers.
That's a really interesting thing, because I'm looking right now at the seller's closing statement involving Mr. Azarian, Sam. And, the problem with it is that this was sprung on Mr. Azarian on the day of closing. I assume that was also done to Gerta Jensen and Richard Olson. There was 3 property owners there running businesses. And it was thrown in, and it wasn't something that was anticipated. It wasn't something that was bargained for or negotiated. It was stuck in there in a take it or leave it kind of way.
Well, and I think they very strongly
Yeah.
coerced at least Sam into
Oh, yeah.
and giving that kickback or that holdback, because they had announced in the local newspaper that the marina was closing. The city had released a press release to the newspaper. What does that do to somebody's business? If all their customers are believing now that they're closing down, that means they have no real future as a business.
Well,
so if
yeah.
you come into negotiations and you expect you're going to receive a certain amount of money, and they say, "Oh no, that ain't going to happen now," well, you can't fall out of the deal at that point.
Well, the problem
It was
is
very, very, very unjust pressure.
it is under the 5th Amendment, the United States Constitution. You have a right as an owner of real estate to just compensation. That's our 5th Amendment. That's in our United States Constitution. It's in the Wisconsin Constitution as well. So if you have the right to that, then you also would have a right to waive that. But you'd have to be really careful. And you couldn't just say, the city says it's not really a public situation. We say it's private. Therefore, sign here on the dotted line and date it. That's not waiving.
Yeah.
Waiving is a knowing, intentional, thoughtful kind of act
Good.
where you're given alternatives and you're provided with information so that you can give up your rights. That didn't happen. Not with Sam, at least.
Right.
Now, if the city knows that that this transaction or that this new development is going to involve government programs, government money, doesn't that make it kind of automatic that it's going to be part, that the relocation costs are there? And if the city knows that, and if that is that the law, first of all? If it is going to be a project after purchase, and they know beforehand it's going to be a project that's going to involve city financing and federal monies and this type of thing, doesn't that make it part of the whole Fifth Amendment relocation costs type of project, and then make it part of the activity?
In our view, yes. But even the Department of Administration is talking to Sam Azarian. Look, this was a voluntary private sale. You're not entitled to relocation benefits. That's essentially what the...
But that's in conflict with what the Department of Administration told Patrick Fagan, correct?
Absolutely.
Yeah.
Oh, wow, I was not aware of that.
Yeah.
So there were two different
In
stories given to two different...
How does that work?
Two different attorneys
How does
coming
that
out of
work?
the Department of
June
Administration.
11th
Sure.
of 2019, the Department of Administration said, in effect, one, you're not really entitled to benefits because it's a private sale. You're not entitled to relocation. But secondly, your leases on the other business are verbal leases. And under the law, it can be no more than 1 year. Since he'd stayed there, until, like 2000, I think it was 2017.
Right.
Since he had stayed there, actually a longer period of time than the 1 year, he forfeited the right to relocation expenses. Now, if you think about it, how much would it cost to relocate a marina?
Well, exactly. Expensive, I'm sure.
Okay? And so, obviously, the city didn't care about it, private business interests. Not these three,
Right.
although Ms. Jensen is probably pretty happy
Right.
about her situation.
Yeah, she actually got more than the appraised
she got
value for her.
1.9 million from her property.
Now, do you
And-
think, Walter, that she had an attorney, and that attorney knew what was going on?
Yeah,
So she obviously got maximum plus. I mean, she got the 140% of her business.
Yes, she did.
Yeah, and the other Sam, without an attorney, really was cheated. I mean, if you by all means, he did not get fair market value, which was about $600,000 less than
Yeah.
what his fair market value was.
actually the property, Sam's property on the marina, was worth about $1.7 million, and the selling price was 1.1 million. And this was a take it or leave it. This was not two business people getting together and negotiating in good faith
Well, what
a price.
got me, Walter, is in your you bring up the fact that, and I didn't see this before, that Sam and Harry, his brother, signed the waiver of the eminent domain, and it was done by the city. So how is it that the city was even involved in this private sale when they had them sign this over? And the other thing
Because
that
it
got
wasn't
me,
a private sale.
well, the other thing was the deed in lieu of foreclosure. I mean,
Yeah.
Blackwell signs the deed over to the city before the closing. I mean, it to me, it's a straw man.
Here's what it says, and I usually don't like to read things, especially in something like this. It said, the undersigned owner understands that that there is no eminent domain, and the city is waiving that the City of Racine has to pay what money would be for just compensation. But lay people don't understand that.
Yeah.
No.
The
No.
Fifth Amendment is a constitutional right. Even police officers have to go through with Miranda warnings and tell the person, what rights they're giving up and go through each one of them and have it waived or given up.
Yep.
Certainly Sam had that right. He doesn't know relocation expenses, moving expenses, and that type of thing. So it's not a very adequate waiver. And that's going to come up in this lawsuit.
What I would like you to do is, mostly for the viewers, because they're not as familiar with this as the rest of us here at the table, if you could just kind of walk them through like dates, what motions were filed, what the decisions were by the judge, et cetera, and I think we'll take a quick break here because we're very close, and then when we come back we'll have you explaining that.